This is Abhishek Sengupta and welcome back. You are listening to Abhishek Sengupta audio blogs. Now we are on with our intellectual property rights series, and in this episode I'm taking up the topic of trade secrets. Now what are trade secrets? Now trade secrets are the intellectual property right on confidential information which may be sold or licensed. Now qualifying for trade secret need to have 3 points. Point number 1 is commercially valuable because it is secret. Point number 2 is to be known to only limited number of people. Point number 3 is must be subject to reasonable steps taken by rightful holders of that information in order to keep it secret. This includes use of confidentiality agreement between the stakeholders, unauthorized use, acquisition or disclosure of such secret information in a manner contrary to the honest commercial practices by others is considered as unfair practice and violation of trade secret protection. In general terms, any confidential information which provides a business or a company a competitive edge and is unknown to others may be taken as trade secret. Trade secret encompasses 2 types of information. Number 1 is technical information, which may include formulas, commercial details, designs, etc. Point number 2 is commercial information, which may include marketing strategy, distribution methods, ad strategy, etc. Depending on the legal system of a country, trade secrets are given protections against unauthorized practices. According to the legal system of a country, trade secrets are given protection against unfair trade practices or unfair practices. This can further be acted upon as per the different provision of laws for protection and usage. The final determination of the violence of the trade practices depend on the situation. However, the owner of the trade secret cannot stop a second person from using the same information if developed or acquired independently. The protection varies from country to country depending on the legal framework of that particular country. In America, as per North American Free Trade Agreement or NAFTA, identifies trade secrets and advocates its secrecy. It was further well defined as per Uniform Trade Secret Act of 1979. Today, almost all countries in the world recognize the importance of trade secrets. Today, the development on the protection of trade secret can be traced to 3 acts. Number 1 is Trade-Related Aspects of Intellectual Property or TRIPS. Number 2 is General Agreement on Tariffs and Trade or GATT. And number 3 is North American Free Trade Agreement or NAFTA. In India, the protection is received through equitable law and traditional rulings and equitable law. The intellectual property rights given to the trade agreements may vary from states to states in India. Now, these rules can differ depending on the situation and circumstances. Now, remember, India is also a member of TRIPS, that is, the trade-related aspects of intellectual property. Under Article 39, subsection 2, TRIPS allow its members the flexibility to frame laws, preventing the unauthorized usage of the information. Many judicial rulings in the recent years have also defined this in a big way. There are 2 important rulings based on this. Let's see. Number 1 is Tata Motors Limited and the state of West Bengal in the year 2008. Now, in this ruling, the Honorable High Court of Kolkata relied the definition of trade secret referring to the Black Law Dictionary and observed that trade secret is a formula, process, device, or other business information that is kept confidential and has an advantage over competition. The second ruling is based on Bombay Dyeing and Meher Karan Singh case. This was in the year 2010. Now, in this case, Bombay High Court has observed an elaborative criteria, now which includes extent to which the info is known to the outside world. Number 2 is extent to which the info is known to the insiders in the company. Number 3 is the precautions taken by the holders to keep its privacy. Next point is the saving affected and the value to the holder. Next point is amount of money spent in developing that trade secret. Last is amount of money and time required to acquire this and make a duplicate info. Next is what happens if there is a violation. Now, as per Indian laws, the specific offense of trade secret misappropriation is not mentioned. However, clauses like criminal breach of trust, theft, cheating may be imposed based on the situations. Some of the famous examples of trade secrets are KFC's secret blend of spices, Coca-Cola's recipe, Google's search algorithm, New York Times bestseller list, McDonald's Big Mac special sauce, etc. The trade secrets and its protection vary from country to country based on the legal framework of that particular country. But overall, this imparts a very significant position in the intellectual property right and the business development. That's all for today. If you got value from this episode, I request you to like, share and subscribe. To my Apple Podcast listeners, I request for a review. I want an honest review how my podcast is helping you and enhancing your life. I'll be back with many such episodes. Till then, stay tuned, stay connected. Have a great day.